All right. Well, I want you to jump in anytime, Jeff. By the way, I want to also compliment Jeff. I've done a lot of training with him, and I really enjoy it. He gets ready, he's prepared, he comes to do a good job, and he does a great job. So this is nothing less than good job by him. So let's talk about this. One thing that's important as of January 1, you've got to have all the information in this addendum as part of your contracts for the sale of a condominium, or as Jeff said, the buyer gets to take a hike at any time. So let's go through this and make sure you understand what's going on. If you have any questions, put them in the chat and we'll get to them at the end. But we'll start with the addendum at the very top. Says it's an addendum of sales contract condominium. That means an addendum means you attach it at the time you're drafting the original agreement, not later after everyone's signed. If you've made a mistake and you haven't attached it at the time everyone signed, it's sure better to do it later than not at all. And that becomes an amendment, even if it's called an addendum. But you need to make sure you get this done. So if you forget to do it and then you realize after the contract's fully executed, gee, I didn't do that. I think subject to your, and everything that I give you advice for is subject to your broker's approval as well. I think you're better off trying to get this thing signed after the contract is executed than not using it at all. So keep that in mind. The top part's pretty.
There's been a recent case where you have to check the box in the sales contract and sign the addendum for it to be included as part of the contract. That's correct?
Well, there is that case, so keep that in mind. But if you're amending the contract, which is what we'd be doing if they're signing the addendum after executing the contract, then I think you're okay because then you're not made, it's not part of the original contract. You forgot it, and these things happen, but you're getting it signed afterward, and I think that'll be part of it because although it's called addendum, we do that with some of our forms at NABOR. There's forms that are called addendum that really are used more as an amendment and there may be forms that are amendments that are really used more as addenda. So as long as you're going to use this, if you forgot to use it, everybody sign the contract. I mean, you can keep your fingers crossed and hope you get to closing and the buyer doesn't back out. But best practice, I think, would be to try to get this signed as soon as you know that it needs to be done. Be that as it may, we've got the first part of it is the seller's name and the buyer's name. And I always remind people that if you're going to do that, your buyer's name on the contract ought to be the way the buyer wants to take title for a lot of reasons that makes things go smoother. But however you've drafted the contract, this form with the seller's name and the buyer's name should parallel what you've put in the contract. The paragraph after that, line after that, is describe the real property and you want to make sure you get that right. I think you're going to be okay if, as Jeff said, you've checked the box for the addendum on the contract form and you attach this and you've put the property description in and you may have made a mistake here. I think you're going to be okay if you got it right in the contract. But again, shouldn't be much reason to get this goofed up because at least in most of the forms software that I've seen, they populate all this stuff automatically. So get it right the first time and you're good to go. First paragraph after that line just reminds everyone that the property is a condominium subject to the declaration of condominium and is subject to the rules and regulations of a condominium under Chapter 718. So that's sort of a warning to the buyer that not only does the declaration, bylaws, rules, and regulations control, but also Chapter 718 of Florida statutes. And that sometimes is a big deal because with these older declarations, the Florida statute, Chapter 718, takes precedence over the declaration for all procedural matters. And there are a lot of things in the statute that have been amended that are different than what's in these old declarations. So that at least tells everyone that 718 controls. The next paragraph we get to are the documents that the seller has to provide to the buyer. And there's an implied provision in the statute that says, the buyer needs to ask for this in order to get it. But the reason that the buyer shouldn't have to ask for it is that if the buyer doesn't get all of these documents and the contract doesn't have these provisions in it, it's an option contract for the buyer. And as Jeff said, the buyer can walk anytime the buyer wants to. Secondary problem for a realtor is if a buyer does not get all of these documents, the buyer may very well claim that the realtor attempted to conceal information from the buyer, especially when the buyer finds out they're going to have to pay those hefty assessments for the reserve items that haven't been previously reserved. So it's in your interest, not only your financial interest, but also your licensing interest, to make sure that all of this stuff gets done and the buyer then can't claim that you didn't do what you were supposed to do because you had some nefarious ill intent. So let's go through that paragraph, and it lays out what's supposed to be provided. And these are all to be provided at the seller's expense. And in fact, the statute says that the condominium association is supposed to make these available. However, the association can charge its reasonable cost of making them available. Number one, the declaration of condominium. Number two, the articles of incorporation of the association. Three is the bylaws and rules, and those are two separate things. Fourth is the annual financial statement. And as Jeff pointed out, the statute now includes the annual budget for the association. That wasn't in the old statute, it is in the new one, it is effective now. So you not only get a financial statement, but also the budget. Number five is a copy of the inspector prepared summary of the milestone inspection report. Now, we talked about those. Those are the structural integrity studies done by an architect or an engineer if the association is 30 years old, or in some cases 25 years old. Then number six, the association's most recent structural integrity reserve study. Interestingly, those are required to be done every 10 years. So even if an association is not with a condo that is 30 years old, it is required under the statute to have a structural integrity reserve study every 10 years. So don't think that they don't have to have them just because they're relatively new. They all have to have these as soon as they have 10 years under their belt. So even if they're not required to have the milestone inspection report, they do have to have a structural integrity reserve study done every 10 years, okay? Then the inspection report described in 718-301 4P and Q has to be provided. Those are turnover inspection reports that developers are now required to provide, and they are inspection basically of a structural integrity reserve report, and it goes beyond the items that you might think of as just being structural, and that's under P and Q of that statute. So those have to be provided by a developer or any association subsequent to July 1, 2023 for turnover purposes. So, and those have to be maintained in the official records of the association. So you'll get those on these newer condos, even if you won't be getting a milestone inspection report or a structural integrity reserve study because they're too new. Also, a copy of the governance form promulgated by the Division of Florida Condominiums. That is a form that the association can provide, and if they don't, it's available on the Division of Condominiums website. It's also available on the forms directory from NABOR. I skipped over the document titled Frequently Asked Questions and Answers. That's under the current statute and was under the previous statute. And if you've gotten all of those documents put together, then you've got all the documents that the buyer is entitled to. Bold print, buyer, by execution of this addendum, hereby requests a current copy of the above referenced association documents, which the seller shall pay for and provide at the seller's expense. And that's under the statute. That is the seller's obligation, and the expense is the seller's obligation. And as I told you, the association can charge its reasonable cost of providing that. Okay. The next paragraph's kind of a big one. It's the warning, and it's required by statute that the agreement is voidable by the buyer. And here's how the buyer gets out of the deal, at least under this paragraph. 3 days after the buyer gets all of the documents that we talked about above, except for the structural integrity reserve items, because this paragraph was required in the old statute. It's carried forward into the new statute. The new statute doesn't require a change in this language, so it means the declaration, the bylaws, the articles of incorporation, the budget, financial statement, rules and regulations. Those are the items that have to be provided under this paragraph, or the buyer has 3 days, not including weekends and legal holidays, in which the buyer can back out from the day the buyer gets that. That means it's important for you to review everything that you're providing, make sure it's all there. A lot of associations will not give you a budget. Maybe they'll give you the financial statement. They may do the reverse. They'll give you a budget, but no financial statement. So it behooves you to go through everything and make sure at least it appears to be there before you give them to your buyer and make sure that it starts the 3 days running. Otherwise, the 3 days never start. Most attorneys, when a buyer says, gee, I really have to get out of this deal, I've had a change in financials, whatever it might be, the first question an attorney will usually ask is, did you get all the condo documents? Because if the buyer didn't, that's a get out of jail free card. So be really important that you take care of that and make sure that gets done. Now, just because the structural integrity reserve and the milestone inspection documents are not listed in that paragraph doesn't mean that the buyer can't get out of the deal if he doesn't get those, because the new statutes dealing with the milestone inspections and the structural integrity reserve studies specifically provide that the buyer may terminate the contract at any time if the buyer doesn't get those documents. So it's crucial that you make sure you do this. What the addendum does is brings the contract into compliance with the statutory requirements for a contract. It doesn't fix operationally what you need to do. So operationally, you need to be sure that that gets done. Jeff, you got anything to add on that?
Well, only that some of this information is now required to be supplied online um, by the recent changes to the statute, or actually to the law, because oftentimes this information was not available, and you had to pay the management company to get it. And I think most organizations of a certain type, I think it's over 100 units. There's a unit restriction in there, but then a lot of this information is now required to be posted online. So at least it can be found without having to reach into your pocket and pay for it.
Yeah, that would be an online access by the seller owner, not by the public or by a buyer. So again, seller providing that, if you're the listing agent, you can contact the seller, and the seller ought to be able to get to the website and be able to get that for you. So thank you, Jeff. That's a good ad.
I think
Okay,
that I'll double check it, but I think it has to be available publicly by virtue of that recent change. But I need to check that before we confirm that.
okay. All right, then we're going to move on to the big bold letter underneath the red line. The red line says the seller should contact the association to confirm the status of the below referenced reports prior to completing this addendum. And this brings another thing to mind for me, and that is that there are some realtors who, in their effort to do a great job, will compile a lot of information at the time that they take a listing, but they don't update that. And that has to do both with condos and homeowner associations. Assessments change, special assessments change, status of these structural integrity reserve and milestone studies will change. So it's a good idea to get this, as Jeff indicated, at the time of taking a listing. But if the listing doesn't sell right away, you may want to try to make sure that it stays current and not simply rely on what you've done previously. So we get down to below the red line, and we've got bold print, and this is required to be in large type by the statute, so it is. The first paragraph is whether the association is or is not required to have a milestone inspection. And we talked about what those were and what associations are required to have those. And then the next sentence is if the association is required to have a milestone inspection, that it either has or it has not. Now, I will tell you that the statute says that these must be done after the local building official gives notice to the association that the study must be done. And I've had some of my association clients tell me that because they have not received a letter from the local government official, they do not have to do a milestone inspection or a structural integrity reserve study. I've explained to them that that's not necessarily a get off the hook. It is not a good excuse. They still need to do it. So, but if the association says that they do not have one, they don't have one. Okay. And your job is not to manufacture one, but just to have this form correctly completed by your seller. Jeff, are we still discouraging realtors from filling in the blanks on these forms?
Absolutely. This is
So,
a potential liability for you and your broker that would be a very bad situation if it was uncovered.
So this is your seller's obligation. Maybe they're needing a little help on how to get the information, where to go to get it. You can help them, but this is for them to fill out. Number two, the association is or is not required to have a structural integrity reserve study. Remember what I said, the milestone inspections are at 30 or 25 years. The structural integrity reserve is every 10. So there are a lot of associations that will check number one saying, no, we don't have one. We don't have to have one. But under number two, they may be required to have one and they may or may not have one. So number two is important. You don't stop when you get to number one. They haven't done the milestone inspection. Well, structural integrity reserve is much more frequent, starts earlier. Number three, the association is or is not required to have a turnover inspection report for a turnover inspection performed on or after July 1, 2023. Talked about that, and those are the structural integrity reserve that the developer is required to do for a turnover after July 1, 2023. So even if the association doesn't have a milestone because it's young, it doesn't have a structural integrity reserve report prepared by the association because it's young, it may very well have the developer mandated reserve study, which has to be given as part of turnover of control to the unit owners and has to be maintained as part of the official records of the association. So each of these each of those three categories are easier or be met by younger associations than older ones. And as you go down the pecking order, you just need to be sure that they're all covered. And even as this moves forward, the older associations will have some of these other things as well. Okay. The next, at the bottom of that page, says if the association has completed the milestone inspection, a turnover inspection report for a turnover inspection or a structural integrity reserve study, the statute requires additional disclosure that the buyer hereby acknowledges the buyer has been provided a current copy of the inspector prepared summary of the milestone inspection report as described in section 553.899 Florida statutes. If applicable, a copy of the turnover inspection report, that's under the Condominium Act and what's required for turnover, and a copy of the association's most recent structural integrity reserve study, if applicable, more than 3 days prior to execution of this contract. Okay. Now, the agreement is voidable by the buyer by delivering written notice of the buyer's intention to cancel within 3 days, excluding Saturdays, Sundays, and legal holidays, after the date of execution of the agreement and receipt by a buyer of all of those items we just talked about. So here is the paragraph that allows the buyer, and the buyer has noticed that if the buyer doesn't get all of these things, that the buyer has the opportunity to terminate within 3 days. So you want to be sure that you do this for two reasons. One, obviously, it helps you earn a living. And number two, it keeps you out of legal and ethical violation issues for failing to do what a professional realtor would do. Anything you want to add to that, Jeff?
No, other than the fact that you just have to build that into your routine as a listing agent, and you also have to make sure that the seller is providing you with this information, or possibly the management company. But this is really important, and I think it greatly expands the buyer's ability to get out of a contract. And they're hard enough to keep together, but losing a contract because this information isn't provided is surely a difficult outcome.
Well, and it's a big deal because after the Surfside tragedy, I think people can appreciate that there were probably lots of people who were reconsidering whether they wanted to buy a Florida condominium because it might be dangerous to live in one. And the Condominium Act itself had its genesis in the desire from Florida to regulate the industry and make people believe they weren't buying swampland when they were buying a condominium in Florida. And I think this is part of that. Not only does it protect the public, but it really, really protects the real estate industry as well because it provides a mandatory disclosure, provides mandatory inspections and reserve studies so that buyers will feel comfortable that they're not buying a pig in a poke, and they'll get a good grip on what the financial cost of owning a particular condominium unit might be for them. So I think there's a tremendous silver lining to this additional disclosure. Now, Jeff talked earlier about a multi-parcel building, and we're seeing more and more of those in certain areas of the county. So if we are in a multi-parcel building, then another section of the Condominium Act requires additional disclosure language. So we've got here, if the condominium is located within a portion of a building or within a multiple parcel building, the common elements of the condominium consist only of the portions of the building submitted to the condominium form of ownership. That's my disclosure because people have often found out that they get into a building and the nice deck up on the top floor is not part of the condominium, and nobody gets to go to that because that's part of the commercial on the top floor. We've got some more in Miami, I think, than around here, where you have restaurants on the top floor of a condominium building in addition to the retail on the ground floor. And those are not part of the residential. So the rest of that language is that the buyer acknowledges that the condominium may have minimal common elements. Portions of the building not included in the condominium are or will be governed by a separate recorded instrument, and that instrument contains important provision and rights. And that can deal with lots of things like the swimming pool, parking, use of other areas. The party, number three, the party that controls the maintenance and operation of the portions of the building not included in the condominium determines the budget for the operation and maintenance of those portions. But the association, meaning the residential condominium association, and unit owners are still responsible for their share. And number four, the allocation between the unit owners and the owners of the portions of the building not in the condominium of the costs to maintain and operate the building can be found in the declaration of condominium or other recorded instrument. Especially in the older ones, those were often skewed in favor of the commercial owner, who may have been the developer and retained the commercial level and then used that as a rental property. Jeff, any comments on that?
No, it's just when you're dealing with a sale in a multi-parcel building, you really have to do your homework. You have to make sure that the buyer understands exactly what common elements are part of the condo association. And as Bill mentioned, what if there's a restaurant or some type of another facility? Could be maybe a workout facility or something that's has nothing to do with the condominium association. And the buyer may, when touring the property, say, wow, look at all this stuff. I'm glad that I'm going to be able to have access to it. And until you actually dig into what is part of the commercial portion and what is part of the condominium portion, you may not know that. And I think you could completely mislead your buyer if you're not careful to understand when you're looking at a multi-parcel building where there's a combination of residential and commercial. You need to make sure you understand exactly what are common elements for the condominium and what are parts of the commercial side. And in addition, the unit owners for the condominium may be responsible for some of the portions of operating the commercial properties. So it's really important you do your homework. Otherwise, you could completely mislead a buyer.
Correct. So we move on. Uh, Lots of declarations provide that a condominium association has a right of first refusal. So the addendum provides that if the association has a right of first refusal to buy the property under the declaration, the seller will, within 5 days after receipt of the association membership's decision, give the buyer written notice of the decision. If the association or membership exercises its right of first refusal, the contract will terminate. I've only had that happen one time, Jeff, where the association insisted on doing that, and there wasn't much anybody could do about it because they had the right to do it. But generally, I don't think that happens, but it can. Have you? What's been your experience?
Well, it's rare, and it's generally older properties where these right of first refusals were there so that the ownership could kind of have some protection over, who's going to be involved in the community. It really is, I don't see it much anymore, but there are some older communities that have some form of right of first refusal, and you need to find that out because obviously you would be putting an offer in and finding out that the offer was not accepted because someone else had right of first refusal. So generally, the docs will tell you that, and you have to have enough information from the docs to determine that, or something in writing from the management company or the association leadership.
No, we've got a few other things that we've put in here that aren't necessarily required by law, but we think are good practice. First is that the hazard insurance, that if the buyer requests, seller is to provide a copy of any and all insurance policies covering property and association. Buyer is advised that buyer may be required by buyer's lender to provide a current hazard liability insurance policy. And when you're buying a condominium, selling one, and the buyer is financing, the lender will invariably want the insurance the association carries, since that's the insurance on the building and the improvements, the hazard insurance. And you'll have to get that through the management company or the whoever it is that's taking care of the association. So this is the seller to provide that because the sometimes the managers are less than cooperative in providing it. The assessments and fines paragraph, we've put in there that all annual assessments levied by the association and rent on recreational areas, if any, shall be made current, and that the buyer shall reimburse seller for prepayments. The seller also is required to pay at closing all fines imposed against the property by the association. And that's in large part because fines by condominium associations are not liens against the property. And some of the rule breakers are aware of that, and they thumb their nose at the association since the association can't put a lien against their unit. However, I'll tell you that associations can refuse to approve a sale because a fine is not paid. And that becomes even an easier process for realtors and closing people when the contract mandates that the seller pay the fine as part of closing. And we can point to that in the contract that the seller has agreed to do that rather than continue to fight it. So that's put in there primarily to try to avoid any issues that shouldn't even exist. The statutory advisory that the listing broker and the buyer's broker are not responsible for errors or inaccuracies contained in the association documents, and that is by statute, and the statute says that. However, if you are aware that there is an error in the documents and you do not bring that to anyone's attention, then I think that this statutory advisory is not going to protect you just as it wouldn't protect you of anything else that you know about that's a defect in the property but failed to disclose. So if you do know something's defective or is wrong in these disclosures from the association, then I think you need to do something about it. And of course, everything I'm telling you is subject to your broker agreement, because if you don't, I don't think the statutory advisory, the statutory protection in the statute is going to give you any protection. Do you agree with me, Jeff?
One of
Okay.
the primary things we're seeing are these transfer fees. Condominiums are not able to charge transfer fees, but homeowners associations are. So this is a condominium addendum, probably doesn't directly impact transfer fees, but as Bill pointed out, they change oftentimes during the course of a contract. And if you don't know them or you know them and you don't point it out, you can really end up on the wrong side of a buyer. So just be aware that some of these fees will change from the time the contract is signed to the time the final closing statements prepared. And if you know about it, it's a great time to speak up before the buyer's asked to sign a closing statement.
Okay, we move on to the last page of the document. And the first couple of lines there, I just want to remind everyone, this is why one of the reasons you don't mix and match addenda, amendment, riders with a contract form. So we all know that there are multiple forms of contracts in use in the state of Florida, and they all have prepared addenda and amendments. FAR forms call them riders. You don't want to mix and match, and this is one of the reasons you don't want to do that. This paragraph says, capitalized terms in the addendum have the meaning ascribed to them in the contract unless otherwise defined herein. This addendum to sales contract condominium is incorporated into the contract and made an integral part thereof. So There's so many terms that we use in our forms and other contracts use where they define the term in the contract form itself, and they do not redefine the term in the addendum. And if you mix and match, you may end up with something that's not properly defined in the contract that you've attached an addendum to, that you're now attaching an addendum, and it creates an issue because we disagree on what the word in the addendum means. So be careful with that. Now this is, then we have the seller signature, buyer signature. Once again, you want to get everybody to sign that needs to sign. Just because they sign the contract doesn't mean they don't have to sign the addendum. If they don't sign the addendum, but they sign the contract, you think you've got the addendum incorporated into the contract. I don't think you do, so be sure everybody signs everything. Then we've got the fee disclosure. There is a continuing request from many that there be a place for sellers to tell a buyer about what the cost of owning a unit in the particular condominium might be, other than for the buyer just to look at the question and answer sheet. It seems that buyers have a hard time trying to figure out what that means. So we've got a fee disclosure provision, which is new, that we've added. We put it below the signature line in the hope that this will not be part of the addendum, but is merely a disclosure. And therefore, if there's a mistake made in filling these blanks in, it won't allow the buyer to back out of the deal claiming that there was some type of misrepresentation or that the contract was incorrect, and therefore the buyer gets to back out. But we've put in association fees, assessments, and other charges as follows, and put in enough blanks that we think will cover everything you might come up with, whether it's, excuse me, for your condominium that you're dealing with, a homeowner association that wraps around a recreational facility association, or even perhaps a golf course. But we don't want these to be part of the form itself, because if you make a mistake, or let's just assume that you've got an HOA, you've got the condo within the HOA, and you've got a golf course, and you only put two of those in there instead of all three, and the buyer comes back and says, well, failure to fill in everything, therefore I get to get out of the deal. Now, if you do start filling this in, keep in mind that if you don't fill them in for everything, you've once again given the buyer the opportunity to claim that you sneakily hid something that you were trying to keep from them because the buyer didn't know what the total cost of ownership was going to be, and therefore you have violated both the NAR Code of Ethics and Florida's statutory requirements that you act professionally as a realtor. I can't deal with that. I'll leave that to you and your broker to discuss, but I'm always worried about adding extra things for realtors to fill in rather than less. And that's my concern. As Jeff didn't mention to you, I'm a rare breed in the state of Florida. I'm a real estate lawyer who also does lawsuits. So I understand how this can create liability, and want to warn you that if you undertake to fill in these blanks, try to be comprehensive with them. Jeff, do you have anything to add to that?
Well, yeah, I think you gave us the correct advice to put this below the signature line. But again, all of these amendments, contract documents are all about your relationship with your buyer. And, I still do my spiel that there's no 401k or retirement plan for realtors. There's a relationship built that is, they know, like, and trust you. They'll continue to do more business with you and also recommend you to other people. That's our main benefit from having a relationship. And the more you put into the relationship and the more accurate you are, obviously the more the buyer will know, like, and trust you. And this is why we added this in there. There seemed to be so much impetus to provide HOA disclosures and other documents, to even for providing the rider A to the FAR contract with the NABOR document, that there was so much momentum to provide this information. Now there's a little bit of an onus on you to make sure it's accurate and make sure the buyer knows that this is all subject to verification.
And then below that, we've got that the information provided by the seller of the association and the management company. And this is required under our contract now, that the seller is to provide this information to the buyer, because Sometimes buyers can't figure out who to get a hold of in order to file the application for approval or whatever it might be. So we've given these lines here to make it easy for the seller to provide the contact information so that the buyer can follow through on what the buyer needs to do. And then a disclaimer language underneath that, the buyer is advised that association documents received by the buyer may not include important information about the communities where the property is located, including without limiting pending foreclosures, types and amounts of insurance coverage, current budget and reserve amounts, status of delinquent assessments, and et cetera, et cetera. So that is a paragraph which is intended to provide some protection to you as realtors to confirm to the buyer that the buyer cannot know, nobody can know everything there is to know about a particular community. We have a separate paragraph similar to that in the contract itself. So you can see that we're trying very hard at Legal Resources to be sure that we have disclosed on behalf of not only the transaction and the parties, but also on behalf of the realtors involved, that buyers need to be aware that no matter how much documentation they get, they may not have all the information about a particular community. Turn it
I
back to
think
you,
it's
Jeff.
I think it's becoming more and more difficult to properly represent all of the aspects of a property to a buyer. And I think things like insurance and inspection items and things like that, we really, that's why we put these classes on. And that's why Bill and I dedicate a lot of our time to make sure that you have a mastery of this, because as we go along, things are becoming more difficult and more detailed, and it's a little more difficult to complete a sales transaction as we add all these complexities. So make sure you come to our classes, speak to your broker, and be up to date on all of these things because they're constantly changing. I did, by the way, Bill, check the uh, House Bill 59. The information on the website is to be provided to the members of the association, not the public.
Thank you, Jeff.
So we can certainly stop our share here and we can go and take a look at the chat and start answering some questions if you'd like, Bill.
I'm ready.
All right, let me bring the chat up here. All right. I'll go back to the start, see what we have. Are multifamily building units considered condos? I think it has to do with the organization of the buildings. That's really, is that decided pretty much by the developer at the outset, or obviously there's a lot of different ways that complexes can be organized as homeowners association or condos. But who makes that initial decision, Bill?
Yeah, well, that's how the developer puts that together. I'm not sure, and I'm not real familiar with a method of putting together a multifamily building that would not be a condominium, other than perhaps a townhouse type of an arrangement where you've got, everybody owns a vertical slice rather than a horizontal slice. And that I think you could put together without being a condominium, potentially maybe a homeowner association of some kind, or maybe none. But I don't think we have too many of those.
Sometimes coach homes can be because there are only, what, 4 units to the building, but
Right.
most of the time you're right. If it's multifamily, it leans toward a condominium. Upcoming year budgets need to be provided for all condos, no matter what age. The answer to that question is yes. Financial statements and budgets. So if it's less than 3 floors, but 30 years and older, not required, correct? But
Correct.
what about the structural integrity reserves? Is that
No,
all three
that's
floors and
still,
up?
yeah, the three stories is the legislature's magic number for having to do all the extra work.
So any condos less than 25 years old does not require the milestone inspection. I guess that's true unless the building official, you're near the water. There might have been some issues with one of our storms, and the building official, I guess, now can say you need to do a milestone in structural inspection. But remember Bill pointed out that it's after 10 years, you have to do the structural integrity reserve. So milestone inspections and SIRS reports be included in the estoppels from the condominium association. I don't think the estoppel is a place for those, is it, Bill? It's
No,
generally
I don't think they'll be referenced at all because the estoppels will show you what the status of assessments is. The Q&A sheet shows you if there's litigation pending, things of that nature. So I don't think you're going to see that at all other than through this disclosure that's required from a seller.
for the brokers. Can we also receive red line copies of the updated sales? If you came to our broker forum last week, we provided you with those. We could find out for you if you want to go ahead and email Marty@nabor.com. I'm sure Marty can provide you with the red lines. We brought them out at the broker forum 2 weeks ago. I don't think we published them anywhere, but I think you're probably entitled to them if you'd like to ask him for them. Do all condos, no matter how many stories, have to provide structural reserve studies every 10 years? The answer to that is no. But the all condos, I guess, do have to provide the studies every 10 years, correct? I might have misspoken on.
Structural integrity reserve studies that those are required only of 3 stories or more. So even if they don't have to have a milestone, if they're not at least 3 stories tall, they don't have to have a milestone or a structural integrity reserve study.
Okay. It's always though, however, speaking of reserves, if you're dealing with any kind of financing, the first thing the lender wants to see is the reserves. So it's still a good idea to have that information available. Milestone report and SIRS report are required to be given to buyers. The answer to that question is yes, if it's a condominium and it's more than 3 stories tall and the age requirements are met, or the SIRS report every 10 years. Is there a specific deadline for when a condominium budget should be available? I'm not exactly sure. Most of the time, those are done annually. They generally get released sometime before the end of each year.
Yeah, the budgets are adopted usually by the board of directors. In some cases, the members adopt it at the annual meeting. If the board adopts it, then it's normally done by the end of the year, although not always. It could be done the next year for that year. And so you wouldn't have a current budget until, March, February, whenever they have the annual meeting. If the unit owners are going to adopt it, that meeting usually happens during the year that they're adopting the budget retroactive to January 1. The statute provides until a new budget is adopted, the old budget continues.
Comment that structural reserve must be provided by an engineer or architect. Do we realtors have liability for the information provided, or an affirmative duty to verify in writing that whomever prepared the structural reserve study? I believe that those studies are signed by the who performed the inspection, and it generally is a licensed engineer or architect, right? I know their
Yeah,
signature
the
at the end.
statute requires that those studies, remember, the visual component of the reserve study or the milestone inspection report be signed and sealed by the architect or engineer. The calculation of the reserves can be done by someone else, but the visual component of all of that has to be done by the licensed engineer or licensed architect with a seal
And
attached to the
they're
report.
generally sealed, yeah. I guess they're always sealed. Does
Yeah,
the
they have to
addendum
be on the statute.
does the addendum need to be completed for all properties listed or ones that began listing at 1/1/25? My first reaction is any property listed after 1/1/25 has to have this addendum. There doesn't appear to be any requirement to go back and provide them for listings before that, but I'll defer to Bill. What's your thoughts on that?
The date of the listing, I don't think matters. I think it's the date of the contract. So the contract executed on and after January 1 has to have this. The listing was executed 10 years ago, or it won't matter. I think it's a question of the date of the contract.
But that means that if I get a contract as a listing agent, I have to have the seller provide that information, correct?
Correct.
You only received the PDF. That's all you were intended to get was a PDF of the new um, the new addendum. So we didn't intend to publish the PowerPoint. Buyers and agents will be asking if the condo complex needs an addendum. It would be great if on the listing contract it states yes or no in MLS. I'm not sure how we would police that, but certainly I think the listing agent that gets this information from the seller at the time of the listing would do well to upload it to MLS, and there's no guessing. If it's not there and you have to supply it signed by your buyer and require the seller to fill it out, that's probably not a great way to go. What do you think, Bill?
I agree. I agree.
Well, let's see. Please address Please address timing and process for existing condo listings. Well, I think we've answered that by saying if you have a listing contract that was signed before the first of the year and you now get in a contract, you have to provide that condo addendum as part of any sales contract written after the first of the year. And that means that if that information is not there, the seller has to provide it. And probably not a bad idea if you're a listing agent, you're not yet under contract, go ahead and get that information provided by the seller, so it makes it a lot easier when you get into negotiations that you have that available and you don't give the buyer the opportunity to walk because it wasn't provided. What do you think, Bill?
I agree with you 100%.
So everybody, I think she's put the link to the PDF in the chat like 4 or 5 times. So hopefully you can find that link. My listing is in a 2-story building, but others in the association are 3 stories. Do they need the milestone inspection? I think it's based on the individual building, not the fact that there may be mixed stories within the complex. Is that okay? You okay with that, Bill?
Sort of. It depends. And you have to be careful with that because some of these condos, different buildings are their own association.
Okay.
Although they all think that the name is the same for everybody, it's Pinehurst or, whatever it might be. So you have to find out if those 2 stories are in with the 3 stories. Well, they only have to do the studies for the 3 story, but still, it's required for that association. And I'm not sure how that would play out. You're selling a unit in a 2-story building, and you don't provide the structural integrity reserve studies. I still think the buyer has the right to get out of the deal if the 2-story buildings is part of an association that's got 3-story buildings as well, because we've still got a lot of reasons why a buyer would be concerned. How much are my assessments going to be? What are the costs going to be? How much, what are the reserves? So I don't think we're off the hook because we're in a 2-story building and the next door building in the same association as a 3-story. I'd play it safe until there's some court case that says it doesn't apply, but I think it would.
We answered this earlier, 3+ stories, including the parking level. Yes, we believe it includes the parking level. Does a 3-day rescission apply to this form? I think it applies to this form if the information is not provided to the buyer in its entirety.
Yeah, and another way of saying that is it's not just the form, it's the information. So until all of those documents are provided, the buyer has 3 days to back out.
Is it necessary if we are in escrow now? Wow, that's a good question.
No, it's not, because if your contract was not signed on and after January 1, then this doesn't apply. So assuming that your contract was signed before today, you're in escrow because you signed it on January 1, it applies. But if you signed it last year, I think you're good to go.
Yeah, I think so basically the bottom line is if the sales contract was signed before January 1, this addendum doesn't apply. Will the condo docs checklist be updated to remind us? You asked for the HOA, but really it's the condo doc checklist that has been updated. And as I say, these forms are all available on neighbor.com. They may not be available in your broker library due to the fact that we've released so many of them so fast. And they don't just put the document up there as a PDF. They program it so the fields all work together and can be filled in. And that's sometimes the delay in getting them out in these DocuSign.loop libraries. Many condo associations do not complete annual financial statements for a couple to several months after their annual cycle. Is most recently available sufficient? I think the answer is the most recent. The condo statute used to say most recent financial statements. So I think that applies to most recent financial statements and budgets, and they may not all occur on 12/31.
Yeah,
They
it's the
can,
most recent annual financial statement, not just the most recent statement. So it's good that you mentioned that because once again, if you get a second quarter financial statement and it's not the most recent annual financial statement, I don't think it complies with the statute.
yeah, and again, a lot of these people do audited financial statements, so you're not going to get the 12/31/2024 until it goes through review and auditing. So you'll get the 2023 version, and that's what you're going to get.
Right.
What do we, many condo associations do not come up, I just did that one. What do we do when an association refuses to provide an upcoming budget? Well, I think you're supposed to provide the most recent financial statement and budget. So if it's an upcoming budget and it hasn't been voted on, I think you got to provide them the most recent adopted budget. I think that would be safe, wouldn't it, Bill?
That's the only thing you can provide. If it hasn't been adopted by the association yet, it's not a budget. It's a proposed budget. So I wouldn't be concerned with that. Maybe I think that's an example of a realtor trying to do too good of a job.
Um, when it says annual financial statement, is that referring to the annual financial report for the master association? Typically, the master association is an HOA and it has one or more condo associations underneath it. So the master association, if it's an HOA, has an HOA disclosure, and the condominium association, part of that master association, is governed by different document requirements. So the HOA disclosure does not require a financial statement. It requires that the current levied amounts are stated and the exact name of the association. So I don't think that would apply. You okay with that,
Yeah,
Bill?
I will point out that if what's called a master association is usually means an association that governs more than just one association. It may govern the rec facilities, it might govern the roads in a development. If it's comprised solely of condominiums, it is a condominium association under the Condominium Act. So, as Jeff pointed out, most of the time those associations that are governing multiple parcels include single family as well as condominiums. So under those circumstances, it is not a condo association. It's under 720, the Homeowner Associations Act. But if it's strictly an association that's over dealing with property in which its members are only condominiums, it is also a condominium association.
Would be organized also and would require to supply those documents in addition to the individual
Yes.
community. Okay. Um, what is the process for everyone who is in contract now and closing in 2025? I think we kind of hit on that, the fact that if you're in contract but not yet closed and the contract was signed on 1/1/25 or after, you have to provide the addendum. If the contract was signed prior to 1/1/25, the addendum doesn't apply. If the structural and milestone inspections don't fall under the 3-day rescission, how do our buyers withdraw if they don't like what they see? I'm not sure I understand that question. The structural reserve accounts and milestone inspections do fall under the 3-day rescission, and they have to be provided. And I guess if they're not provided and the buyers don't like what they see, they have the right to rescind. Bill, that's the only way I can respond to that. What do you think?
Yeah, I think that may have been a misunderstanding of something that I said, which is the mandatory language that we talked about with the articles, bylaws, declaration, that's in one section of the statute. The mandates with respect to the milestone and the structural integrity reserves is another. Under the old version of the statute with the one paragraph, that's a 3-day right of rescission for that. There's also a 3-day right of rescission for the milestone and the integrity reserve studies.
Should we, for every condo, just check box one, regardless of the height of the condo, that if it is not required on either structural or milestone? Well, the condominium addendum is going to be required for every condo. You're just going to check the boxes that a milestone inspection is not required, right? I mean, it's still going to be required for every condominium, and the documents, as requested, still have to be provided. I don't think that the fact that it doesn't require the milestone structural inspection, or it's not in a multi-parcel, it still has to be provided, and the information still has to be provided to the buyer. Would you agree with that, Bill?
Yes, because what we've done is we've taken everything required for a contract for a condominium and put it in the addendum and taken it out of the contract itself. So whether or not it's got a structural integrity reserve study, milestone reports, 2 stories or less, there's language in here about the declaration, articles, bylaws, etc. That has to be made part of the contract with the addendum. So you've got to use this addendum in every single sales contract involving a condominium.
Therefore, condos built in 1989 through will not have a turnover inspection. I think maybe we didn't quite cover a turnover document is when the developer turns the property over to the homeowners, and that's when an inspection is done, and that must be provided regardless, I think, of when it was built, right? I don't know that the 1989 means anything. Condos get turned over all the time, right?
Yeah, the effective date for the developer mandated structural integrity reserve type study be a part of their documents is July 1, 2023 for any turnover that takes place on and after July 1, 2023. The developer would have to provide that information.
So it was turned over anytime before July 1, 2023. There's no requirement to provide that turnover document.
That's correct.
I am taking a listing that is 4-story building built in 2017 and has 30 units under one roof. Association did provide a 30-year alternate funding plan. Is that sufficient?
Well, the associations are allowed to use an alternative method for funding whereby they pool all of their expenses and they have a formula that shows that on any year, by pooling all of these expenses, they've got enough money in that year to pay the bills, including any reserves that need to be drawn from. And I'm not an expert on how to use that formula and how to prepare it. I'll, rely on the accountants to do that. But if they use the alternative funding mechanism under the Condominium Act, that will be sufficient. But they've still got to fully fund everything, whether they're using a straight line for each item funding or they're using a pooled funding approach. They've got to be able to pay the bills without having to issue additional reserves for all of the structural issues.
Okay. What is Marco Beach Ocean Resort in the Apollo? I'm not sure I understand that question, Cindy. Can you help me, Bill?
That was a hotel. That's a hotel operation. That's actually a commercial property. I want everybody to understand, just because they've got places people can live doesn't make it a residential condominium. That particular property, as I think, is the Registry in Naples, and you can correct me if I'm wrong, Jeff, and a few others. They're hotels that people can buy units in. If it's a hotel, you can buy a unit in. It acts like a condo, but it's a commercial property, and it may be a condominium, but it's a commercial condominium. And this statute only applies to residential condominiums.
Well, the Ritz-Carlton is a great example of that. So there
That's
you
a
go.
perfect example.
Are older co-ops affected by these regulations? The co-ops themselves, I know we redid the co-op addendum, but I'm not exactly sure how that applies to condominiums. Did we just freeze?
No, I'm still here. Are you there?
Yeah, your picture just froze and I was panicking a little bit there. Okay. I'm not sure how co-ops, there is a separate co-op addendum that we've updated to
Yeah,
provide,
co-ops are covered by the same rules.
so they still have to have the milestone inspections and the structural reserve accounts.
Same dates as the condos. That's correct.
I know there's a receipt of documents for the condo that we'd updated also. Should we, for every condo, let's see, I think we did this. I somehow moved back a little bit here. Hold it. Moving on along, right along here. Is the language addressing not yet disclosed assessments written in the sales contract? It doesn't mention anything here about that. Okay, so Bill, we're talking about, I think, pending special assessments. And that language remains the same, but I don't think it gets disclosed in the condominium addendum because it's not yet assessed.
Yeah, that's correct. I think a lot of associations will include information about a pending assessment because they've been.
I think we lost you. I think we lost you, Bill. I don't see you on the screen anymore. Is it my internet or is it
No,
Bill that we,
he is gone.
pardon? Bill's gone?
He is gone.
Okay. Well, we'll try to move along here until he can get back on. But where are we here? Fee disclosure, just condo or include HOA. The purpose of the fee disclosure underneath the signature line in the addendum is just for the condo fees that apply to that addendum. Do you have to list capital contributions in the fee disclosure on the addendum to sales contract? Capital contributions are part of the information that need to be provided to the buyer, regardless of whether it's a condo or an HOA, and they are referred to in the sales contract as information that must be supplied to the buyer. People are asking for a break. Well, we're at 2:30. I guess we could take a short break. We got another 20 questions and see if we can get Bill back. Are you back, Bill?
Yeah, I had to rejoin.
Okay. What do you think? Do we need to take a break? Someone's asking for a break.
No, I'm good. Let's go ahead and wrap it up. So anyone wants to take a break, they can take
Try
a
to
break
get
and come
you
back.
a break at the end.
Yeah.
Are the fee area is optional on the condominium addendum. It's not required. The numbers are not locked in stone, and there's not any liability to the provider. So we also need to include HOA fees in addition to the condo fees in this form. That would be negative. The HOA fees are included in the HOA disclosure, and the condo fees are going to be included in the condo addendum. There would be no place to disclose both.
Yeah, and that's important. That's important. You could put HOA fees there, but it won't satisfy the statutory required disclosure on the HOA disclosure form. So you still got to use the HOA disclosure form.
Does this fee disclosure take the place of the HOA disclosure? No, there are two different statutes. If you've got an HOA involved, it uses the HOA disclosure. If you've got a condo involved, it uses the condo addendum. Do we have the choice to leave the condo fees off the form? Yes, you do. That's completely optional information. And it is, by the way, provided by the documents, which is the way we've always opted to provide that information in the 7 documents that include the financial statements and the budgets and all that. But everybody seemed, kind of hell bent, if you excuse my expression, for putting some of the fees somewhere so the buyers could see it. And we kind of added it on a non-binding basis to the condominium addendum. If we are under contract for 2024, no, you do not need to add this form unless you go under contract as of 1/1/25. How does this change, or does it change receipt of condo docs? The receipt of condo docs has been updated to provide the requirements by the statute of all 9 things that you have to provide. So are you suggesting we don't fill this fee disclosure out to protect ourselves? No, Bill guided us very um, intelligently to say if you put something in those fees below the signature line, they're not cast in concrete and they're not a liability to you. However, you still have a relationship with your buyer and you still have some responsibility to make sure you're putting the correct amounts in there and letting the buyer know that some of this may be subject to change.
But
Is
I
it,
will point out that if you do fill those numbers in, it doesn't mean you don't have liability. We're trying to help avoid liability by putting it under the line, but there's no guarantee that putting it under the line escapes liability entirely.
there you go. Is it best to have the buyer's agent ask the association representative to fill this out since they have to fill out check boxes on page 1? It's the seller that fills out the boxes and the items 1, 2, and 3, not the association. If we use a worksheet listing fees, combos need more space to fill it in. Shall we have the buyer and seller initial at the bottom of the page and attached to the sales contract? I think she's talking about the community fee disclosure, which is strictly a voluntary form and has no real attachment to the sales contract, right? It's strictly informational. That we put that form in there for people to be able to disclose information, but not have the liability of the sales contract. And I think Bill would tell you that he's not a big fan of that form.
I am not a big fan of that form.
If the condo association collects HOA fee with the condo maintenance fee each month and then dispenses to HOA, do you need a separate HOA disclosure also? Yes. If there's a master association, Pelican Marsh has the Pelican Marsh Foundation. The condo association collects those fees and gives the portion to the Pelican Marsh Foundation, but you still have to disclose the fees that are going to the Pelican Marsh Foundation, even though they're collected and paid by the condominium association. I hope that answers your question. Is this form required for condos less than 3 stories? Yes. As Bill pointed out, we took all the condo language out of the sales contract and put it in this addendum. So if it's a condo, you have to check the box in the sales contract and include this condo addendum. Otherwise, the buyer really has a right to rescind at any time. Let's see. I had a sales contract effective date end of 2024. Should I add the new addendum? I think again, same time, same station. If it went to contract prior to 1/1/25, you did not need that addendum. If a condo was built in 1970 and is in Naples, close to the coast, when is the next milestone inspection report due and the next structural? Well, that would make it 54 years old, right? Well, I would think it would be required in this cycle.
Yeah, it would have been required by the end of the last year.
Well, yeah, because it was more than 50 years old on July 1 of 2022.
Right.
So, or more than 30, excuse me. The form is in form simplicity. Yay. Like I say, this thing will start popping up in your broker's forms library. It's just a matter of we can't guarantee that's in there now. Are co-op buildings affected by this regulation? Yes, they are. If they're based on their age and the number of stories, they're required to comply whether they're co-op or condo. Required turnover inspection reports will not be retroactively required just beyond July 1st, excuse me, of 2023. Correct, Bill? Yeah.
That's correct.
If a condominium is aware of issues and has not completed the inspection report until after the repairs are taken care of, how do we handle this situation? Well, technically, I guess if they don't have the inspection report completed and available to show to a buyer by now, they'd probably be in violation. You'd have to tell the buyer, we don't have this report, and you'd have to make your judgment as to whether you want to continue with the purchase. I don't know
Well,
how else.
remember the addendum form, we include language that says that no matter how many documents, no matter what you get, you may not know everything there is to know about a particular association or community. So that helps to keep the realtors out of hot water. I will say that the statute provides that if the association does not do a required milestone inspection or structural integrity reserve study, that's a breach of a director's fiduciary duty and could expose the director to personal liability. So associations not complying with the statute do so at significant peril to their directors.
I think there's language in there that it's a felony situation if you tamper with these reserve accounts or don't follow the rules. So, can you refresh on the turnover inspection report, Bill?
That's anything July 1, 2023 or later, the developer has to turn over a report with both a structural integrity reserve study, which has a list of items under that particular statute, which goes beyond the structural integrity stuff required under these new rules that we're talking about. And that doesn't require that a milestone inspection report be provided, only a structural integrity reserve study. And there's about I don't know, about 15 or 16 items under the two different sections of the statute that have to be included.
In reference to my question about a pro forma budget, I'm referring to an association so they will not provide them. Some of the smaller associations are really not familiar with the law. I had a situation where I had to send the law to the president of the condo association, who reluctantly told me that she'll provide them to comply with the law. She initially told me she wasn't going to provide anything. And I said, okay, well, here's the statute. Maybe you might want to refresh yourself on that. She was an attorney too, so there you go. Okay. Um, can the buyer sign this form first and wait on the seller to fill out after a contract is sent to the seller? The answer is yes, but it's a little bit dicey for the buyer because until that seller fills that out and signs it and provides them with the documents, I think they're kind of sitting on a 3-day right of rescission from the word go, aren't they, Bill?
Yeah, I think you meant dicey for the seller because the buyer has the option at any point to
Right.
back out of the deal till they get everything. So I think it behooves the seller to get everything to the buyer right away.
Yeah, I misspoke on that. My apologies. It's dicey. The seller could lose the contract if they don't provide the information. Co-ops are not included, correct? No, co-ops have to follow the same guidelines as condos with regard to buildings that are 3 stories and above. In the fee disclosure section, it states association fees. Why does it not state condominium association? Doesn't that create possible confusion? Well, we appreciate thank you. It's a condominium addendum, so there doesn't appear to be any place to put HOA fees in there. I'm not sure, maybe we could have been more specific, but being that it's a condo addendum, probably we figure that's the place you put condo fees. Bill, anything there?
No, that's another reason I wanted to push it below the line of signatures. And I don't like any extra disclosures that aren't required by statute because every time there is something that needs to be filled in or can be filled in, there's a potential for a goof or liability. That's why I don't like those things. So here it's a question of filling it in or not, but realtors are going to put down there what they want to put down there. And if the realtor fills it in, the realtor has liability.
What if the structural integrity reserve study is not completed yet and scheduled for later this month?
That'll be answered in the addendum. It says that they are either required or not required, and then they have one or they don't have one. That's what it'll say. They don't
Again,
have one. Statute doesn't let the buyer off the hook because the buyer only gets the document if it exists. And if the buyer signs the addendum, signs the contract, the document did not exist at that time, but it came into being later. Well, at the time of the contract, the 3 days, the buyer would have all the documents in existence at that time, and the 3 days would run from the date that the buyer gets everything that the buyer could have received on that date. So if they get something later, it doesn't restart the 3 days.
And that also gives the buyer the right to rescind if you don't have the information to supply to them
Yeah,
timely.
absolutely. Buyer looks at that, says, you don't have the structural integrity reserve study. I haven't gotten it. I'm out. I have my 3 days. I've seen what you can or can't give me. I'm not going to buy this unless I can see that kind of information.
Right, because it could be significant in the cost of ownership of that of that unit.
Yeah,
Uh,
especially on the older ones, I think it's going to be hugely significant.
there are 6 boxes to check, not 3 for the structural. Okay. Is there a state portal to obtain any information regarding reporting? Mm, I,
The division, you have to report the structural integrity. I believe you have to report the structural integrity or the milestone inspection to the Division of Condominiums or the DBPR. I haven't looked at that because I haven't had any of my clients ask me about that, and that's not a question that really has to do with the contract. But that would be as far as I think you could go. I think it's either the Division of Condos or the DBPR do get a copy of one or both of those reports or a confirmation that they've been done. Maybe I can't say that for sure, but to my knowledge, there's no state website that you can go to and get information on a condo or a cooperative to see what kind of studies they have.
my guess is it also gets submitted to the county based on I read the Collier ordinance there. The building official gets a copy of that report also. Will the condo receipt document with the checklist, articles, rules, once signed by buyers, starts the 3-day be changed? Yes, it has been changed. Again, I'm not sure exactly when it's going to show up in the broker libraries, but it has been changed on neighbor.com. Will these milestone inspections be required for a 5-unit townhouse complex with a legal description as condo? If it's organized as a condo, regardless of the architecture, it still has to, it still has to comply with the rules. And if the townhouse is 3 stories or more, maybe parking underneath or whatever, it still would have to have the inspections.
I believe so. There's an exception for, uh, of less in the statute, which seems to allow some townhouse developments to be off the hook. I don't think it applies, but I think the safe bet is realtors ask if the association says we don't have it, we don't have to have it. Uh, that's the association providing that information. And if the realtor relies on that in good faith, remember there's a safe harbor in the statute that we've put in there. That's the statutory advisory. It says that the realtor doesn't have liability for anything that's wrong with the information provided. So I think you're going to be okay with that.
Can we clarify this addendum applies to co-ops? Yes. Again, yes. Um, just to clarify, properties like Naples Bay Resort and Bella Sera, both are condo hotels and zoned commercial, do not require the 10-year reserve study report. If they're commercial condominiums, this addendum doesn't apply. They're commercial and they're governed by commercial rules and regulations and documents.
Yeah, there
Is
are
it
a lot less protections in the condominium act for commercial property. The 80% of what's required under the act is residential only. So this is another example where they figure business people don't need protection like people buying residences, and so they're not given the same protections.
the condo docs do not include condo doc receipts do not include structural report. I I know when I did the PowerPoint, I noticed that. I'm not sure that we need to review that and make sure because it should, if the structural integrity report is required to be submitted along with the milestone inspection, we'll need to change that form. So I'll check that out for you. Thank you, Tom. Until we get all these forms in prescription, should we not have seller's attorney review documents? Well, Bill will answer that.
Well, I always think that attorneys should review as much as they can because we're deal helpers, not deal breakers. So I think that it's a good thing to do. Too many times in my practice, I've had polite realtors not want to bother me with something, and then when I finally get bothered, it's a much bigger problem than it would have been had I been bothered earlier. So from my perspective of practice, I think that real estate lawyers would prefer that you reach out to them earlier than later.
Circling back to my question of 1970 built condo, I didn't hear a definitive answer. A condo built in 1970 by 2022 was 52 years old, more than 30, needed a condominium or needed a milestone inspection and structural reserve studies. Did you say as of July 21, the first milestone was due, then 30 years subsequent? No, sorry if weren't clear, but it's buildings that are more than 30 years old as of July 1, 2022, which includes your building that was built in 1970. So hopefully that clears it up for you. Once the buyer signs the receipt of documents, is this a done deal? Well, it means the buyers relinquish their right to rescind based on the statute.
Yeah, let me jump in for a second. I just want to point out that one of the reasons that the receipt for condominium documents does not have these things added is at the bottom of the addendum. It says the buyer hereby acknowledges the buyer has been provided a current copy of the inspector prepared summary of the milestone inspection report as described in the statute, and a copy of a turnover inspection report, and a copy of the structural integrity reserve study. So the addendum itself, by signing it, the buyer signing it, saying I got this stuff.
And the receipt is not required by the statute. So
that's correct.
We like to have the receipt, and many listing agents get quite angry and they don't get it. But we looked at the statute several times, it comes up every year in contract review, and we can't find anywhere in the statute where that receipt's required. So strictly an option to return to the seller's agent, listing agent to confirm that they have the documents. Let's see. These are two separate forms. I don't understand what the question is there. So we were led to understand that if a contract goes pending in 2024 and closes in 2025, the new condo law still applies to the pending contract and disclosure must be made. It sounds like this is not the case. I think we've said, maybe we haven't said it consistently, but if it went to contract prior to 1/1/25, the addendum is not required. Right, Bill? I mean,
that's correct. That's correct.
All right, we're getting down toward the end here. The new addendum indicates financial report and budget. Is it referring to the year-end financial report? It's the most recent year-end report and the budget for that year. It may not be 2024 if 2023 is still being audited and waiting to go for 2024.
And it's not a report, it's a financial statement. So that's the proper terminology, and that's an accounting term.
Sometimes it's audited, sometimes it's a compilation, but it's generally the most recent financial report. So, Bill, we got a compliment here. You both are walking encyclopedias.
I hope I can convince all the judges of that.
I would defer that to you more than me, but I'm still trying.
Thank you. Whoever gave us that compliment, thank you.
City of Naples need milestone inspection report, 3-story. In the website, it's in the City of Naples website. If you look up milestone inspection reports, it cites both 30 years and older as of July 1, 2022, and 25 years older within 3 miles of the Gulf. So I know the Collier County the Collier County would be they've enacted a statute, or it would be a statute or whatever you would call it that the county enacts, struck the 25 and over language and just said it's up to the building official. The City of Naples website still says that they want the structural reserve study done and the milestone inspection report done for buildings 25 years or older within 3 miles of the Gulf. Well, some nice thank yous here, Bill. So I think that's time to wrap it up. It's 2:52. We'll give you 8 minutes of your life back. And thank you for this opportunity. And most of all, thank you to Bill. You certainly spend an awful lot of time giving back to realtors. And from me and from all of us, we appreciate you.